So, in the chapter offer and acceptance, when we talk about the definition, so meaning of offer says that when a person shows his willingness to do or not to do something with a view to obtain assent of that other, uh, with a view with respect to such act or abstinence, it is called that he has said to have made a proposal. If we talk about the essentials, so essential says that there should be expression of willingness with respect to that act or abstinence, or there should be the intention should be to obtain assent of that other particular activity. Now when we talk about characteristics of offer, so characteristics of offer says that there must be the subject matter, which should be to do or not to do something, or it must be made to another person with respect to obtain assent of that other. When we say that obtain to assent of that other, so it means that the party should not be having something in mind that the person is already having that thing, or the other person is all say going to say no for the particular offer. So if the intention is that, it will not give rise to a valid offer. For example, A has purchased a new car last week, and B offers that whether he is willing to buy his second hand car or not. So he is already aware of that he has already purchased a new car. So it means that this particular offer will not give rise to a valid offer. Then another important essential element is that the expression of willingness must be made with a view to create legal obligation. So if any offer is being made, and that offer is being made for the social commitments or your non-economic or other needs, so in that particular case there is no intention to have legal relationship, then this particular offer will not be regarded as a valid offer, though it will be accepted, but it is not capable to give rise to a valid contract. So if there is no intention to have legal relationship or legal obligation, then in that case such offer is not capable or is not regarded as valid offer for the formation of the contract. Then in continuation, when we talk about the kinds of offer, so there can be express offer, implied offer. So as we discuss about the express contract, so express in words spoken or written, when the willingness is shown this way or the offer is being made, then in that case there is it will be known as the express offer. And implied offer is being that when the conduct of the parties or the circumstances or the behavior, all these things are such which indicates that the offer is being made, then in that case it will be known as implied offer, right? And another kind of offer is known as the specific offer and general offer. Specific offer is one which is made to a definite or a particular person. So if A is making a proposal to B, or B is making a proposal to C, so in this case the offer is being made to some specific person. And when we talk about the acceptance, so when we talk about in case of specific offer, it can be accepted by the person to whom it is made. So if it is a specific offer, so no one else other than the person to whom the offer is being made can make a form the contract or accept the offer. So for example, A says to B that I want to sell my car, and C comes in between and says that I am ready to buy your car. So now in this particular case, it is not the offer which is being made by A to B and accepted by C. In this case, C is making a separate offer to A, and offer plus offer does not give rise to promise. So there needs to be that the person to whom the offer is being made must accept the offer, then it is going to result into the promise. And considering all the essential requirements are here, then in that case such promise will turn into the contract. And once it turn into the contract, it gives rise to legal obligation. And if there are legal obligation, so in that case you are bound to perform. If you do not perform, the other person has right to go to court of law to claim the performance or compensation for non-performance. So in case of specific offer, it can be accepted by the person to whom it is being made. And when we talk about the journal offer, so a journal offer is one which is made to public in journal. So we'll discuss other things also. And here we will discuss a case of Carlyle versus Carbolic Smoke Ball Company. But we'll discuss it later, because first we need to understand what are the prerequisites or what are the other things which are required to exist for the acceptance of offer, or what do we understand by the other essential elements of the offer. So I hope the things are clear to all of you. As of now, just to go through again: meaning of offer, then we talk about the essential elements other than definition. After the definition, the explanation of the meaning of offer is there. Then characteristics of offer is there. That what do we understand by the basic requirements or basic characteristics. Then we talk about kinds of offer, wherein we have discussed about on the basis of express offer, implied offer, specific offer, and journal offer. So this express and implied offer is on the basis of mode of formation, and the this particular offer is that to whom or to which party the particular offer is being made. Then after that we come to the rules regarding valid offer. This case law we are going to discuss at the later stage, when we'll discuss about the journal offer after the situation of acceptance. Now when we talk about rules regarding valid offer, then in this particular situation, the very first rule is the intention to give rise to legal consequences or be capable of creating legal relationships. So when we use the term agreement, we talked about the essential of legal obligation, right? When we talked about the essential elements under section 10, the first essential we talk about that the intention to create legal relationship, right? So it means that when we talk about the agreement, so agreement emerges from the promise. We say agreement emerges from the promise, and promise emerges from the offer and acceptance, right? So when we talk about the offer, so offer must satisfy all the prerequisites of a valid offer. तो valid offer वो कब कहलाएगी? When it has all the legal requirements fulfilled in the as per the Indian Contract Act. So these conditions we are going to discuss here. So very first condition says that it must give rise to legal consequences or capable of creating legal relations. So what does it mean? That if there is no intention to have, for it does not give rise to legal obligation, or there is no intention to have legal relationship, so in that particular situation such an offer will not give rise to a valid offer. So in this case there is that what was the intention at the time of making an offer, at the time of formation of the agreement, plays a very important role. So we say social offers or social engagements do not make valid contract. There exists no intention to form legal relationship. So what was the intention at the time of making the proposal when the offer is being made plays a very important role, right? So in this case, the case law, which we have discussed, Balfour versus Welfare, so there also the judgment held that there was no intention to have legal relationship when such promise was being made, when the offer was there. Then in that case, on that ground, it was said that Mr. Balfour was not bound to pay any sum of money to Mrs. Balfour. That particular circumstances situation does not exist in the form of the contract. So we say that again, we have already discussed this case law. Balfour and Mrs. Balfour were enjoying their leave in England when Mr. Balfour was to return to Ceylon, where he was employed. His wife was advised to stay in England due to her ill health. Mr. Balfour agreed to send a monthly sum of money, 30 pounds, as maintenance allowance till she remains or stays in England. He did send the amount for some time, but later, due to differences, he stopped sending the amount. Wife has filed a case against him, and suit was dismissed. Suit was dismissed as there was no intention to create legal relationship. So that this particular situation did not emerge in form of a contract because there was no intention to have legal relationship, hence does not give rise to legal obligation. So अगर आपकी legal obligation नहीं है, so you are not bound to perform that. So as per this, we say that an offer will be considered as a valid offer when it is capable of giving rise to legal consequences or capable of creating the legal relations. So I hope this first essential is clear to all of you. Then the second essential says an offer must be clear, definite, certain, or capable of being made certain. So if you remember the essential element that talks about the certainty and possibility of performance. So if the particular situation is such that the particular thing is not clear, that particular thing cannot be performed, so how there can be a contract related to that? So for that thing, whenever the offer is being made, it should be clear, clear with respect to the subject matter or about what thing we are entering into the contract, or how it will be performed, or what will be the other terms and conditions. So if there are vague terms and conditions, or the particular thing is not clear, then in that case such an offer will not give rise to a valid offer. For example, A says that I am very creative, very innovative, and I am going to design your house, design your dream house. Now, in this particular case, there is no clarity. What is the dream house? No specification, no details. Or when we talk about that being innovative, there is no definition that how this particular innovation can be defined. So there should be certain specifications, certain terms and conditions, certain designs must have been shown, that these are my designs and these are the things which are there. So in that case, the details should be there, certain kind of examples should be there, or where it is, if it is not clear or not certain, but it is capable of being made certain. So certain designs is, suppose you have shown 20 designs, your earlier projects, and out of the 20 designs you have probably mixed 2 or 3 designs. That's perfectly all right, right? You have shortlisted certain designs and you have shown that out of all the design, I like these 2 3 design, so I want something similar to this, something similar to that. So in this particular situation, though it is not clear, but it is capable of being made certain. But if we use the vague term that I am going to design your dream house, so that does not make any sense. So and later on there is a dispute that I have dreamt of, or I have thought of this particular level or this particular thing, and you have not even incorporated 20%, I am not going to make any payment to you. So in that case, there will be dispute and it will not give rise to any legal consequences. So an offer must be clear, must be definite about what thing, how we are going to do about it, must be certain what we are going to cover, or capable of being made certain. Example here is given that an indefinite or vague offer cannot be accepted. It means cannot give rise to the legal obligation, cannot give rise to the contract For example, sale or purchase of oil does not indicate that which type of oil you are going to purchase. So if a dealer is of coconut oil only, then it is not vague. So if A goes to B that I want to get this much quantity of oil, and he is dealer in only one type of oil, then it is not vague. But if there are 20-25 types of oil are there, and you say that I want 5 liters of oil, so which oil you need, which are, what are the specification. So it does, you have asked 5 liter of oil, and you wanted the oil to cook your food, and he has given you kerosene oil, and end up in a mess, and you came back and returned it to the seller that I have asked for the cooking oil, or I have asked. So he said you never specified the oil, which type of oil you need, so it is also the oil. So in that scenario, this particular situation will not give rise to a contract, right? I hope it is clear to all of you. Then the next essential is an offer must be distinguished from a mere declaration of intention. Now, when we talk about this particular point, so we say that offer must be made with a willing, two points we have covered. One is that offer must be made with a view to obtain assent of the other, right? And we say that the person should be willing to do or not to do. And third thing, we say that the person must be capable to do that thing, right? So if we combine these three situations, it says that if we are just, declaring our intention, so it means that you are planning, or offer will be made in near future. So if there is no offer, you are not willing, it will not give rise to a contract. It cannot be accepted. Right? So it means that an offer must be distinguished from mere declaration of an intention. So the offer to do or not to do something must be made with the motive of getting the assent of the other party to whom the offer is being made. तो अगर हमारी इंटेंशन ही नहीं है वो काम करने की, या हम केपेबल ही नहीं है, या वी आर जस्ट किडिंग और वी आर जस्ट सेइंग इट फॉर सेइंग सेक, it will not give rise to the valid offer. So in this case, when we talk about this particular case law, a father told his would-be son-in-law that his daughter would have a share of what he would leave after the death of his wife. So it was held that the letter contained only a statement of intention only. There is no offer is being made that my daughter is having the share, and in return you will, because you are marrying to her, so you will have the share in the property as well. So there is just an intention. So when we have just declaring the intention, so this intention does not means that there is offer. So intention or just declaration of intention does not give rise to the offer. And if there is no offer, so it is not a valid offer. That intention is not a valid offer as per law. If that intention is not a valid offer, so it cannot be accepted as well. Right? Then the I can say the last point for today's class, the remaining essential we'll discuss in the next class, because I don't want to overload you guys with the more number of concepts. So just the last point for today's class: an offer is distinguished or different from invitation to offer. So here, when we talk about step 1 for the formation of contract, so there needs to be offer plus acceptance, right? So at first stage, there needs to be an offer, and second stage it needs to be accepted. But if there is an invite to offer, then in that case this invite to offer will become step 1, the offer will become step 2, and acceptance will become step 3. So when there is an invitation to offer, so in that case we are inviting the other parties to make an offer. So if there are certain we can say that goods are there with price tag, so we look for the goods and we ask the person, that ask the seller, that whether this product is available, or I am ready, I want to buy this product. So in this case, whether this product is available, or any color or size or other design, etc., is available, or this particular product I am willing to buy. So when I say I am willing to buy, then the seller has the right to say yes or no. So just by saying I am willing to buy, it does not mean that there was the particular product and there was the offer to sell that product and I have accepted, and the buyer cannot say no to that. In this scenario, this goods with price tags was an invitation to offer, right? And this invitation to offer, that it is inviting others to make an offer, and when the offer is being made here, when we ask the seller, so then the particular seller is in the position of the acceptor. So he can say yes or no, it is his sweet will. So whenever we talk about the acceptance, so acceptance, till the time the other person does not accept the offer, there is no contract. So for an offer to become a contract, it needs to be accepted, and acceptance should be valid acceptance within the meaning of Indian Contract Act. So we say that an offer must be understood as different from invitation to offer. In case invitation to offer means receive offer, the person sending out the invitation does not make an offer but only invites the other party to make an offer. Such invitations for offers are not offers in the eyes of law and do not become agreements by their acceptance. It means that once the offer is invitation to offer is being made, this invitation to offer is being made, and once this invitation to offer is accepted, it means the offer is being made, then in that case it does not give rise to the agreement, right? So it means if there is an offer and it is accepted, there is a promise. But if there is invitation to offer and such invitation is accepted, then in that particular case, it does not give rise to the agreement and consequently does not give rise to a contract. So for example, an advertisement for the sale of goods, quotations when invited, catalog of prices, displayed of good price mark thereon, do not constitute an offer. So in that particular case, we have to understand that the offers are not emerged from the invitation to offer. So there needs to be an offer first and it needs to be accepted at later stage. One example can be advertisement for sale of goods by auction. So when auction takes place, so in the auction, what happens, that there is an invitation to the parties that they can join the auction sale, right? So when they join the auction sale, so that time the particular products or the particular items for which the auction takes place, so there the announcement is being given that these are available, and when there is a bid by a person, so that person gives a bid, so it means the person is making an offer to buy the particular product. So you must have seen in most of the movies, serials or series, etc., that the auction is taking place, and there is an invitation that auction sale is going to happen for the particular product, and these products and items are available. And when these are being announced, the bid and offer is be made by a person who joins the auction. And when there is the announcement and three hammer are being there for this, then it indicates that there is the acceptance. And here the stroke of three hammers are considered as implied acceptance, because the behavior, the conduct as per the trend is, showing that the acceptance is being made. So even that person has not said yes that this goes in his name, so even that the three hammer stroke is there, so it is considered as accepted. So it will be one good example of implied acceptance. So when we talk about this case law, Harris versus Nickerson, so in this particular case, P, an auctioneer, announced that on a specified day an auction will be held. A traveled all alone to London for the auction and found the auction has been cancelled. He sued for compensation, and this case was rejected on the basis of that this is mere a statement and not an offer. So in that particular case, there is an invitation to offer that the auction will take place, and then the person is going to make the offer. So intention or declaration and invitation to offer are different from the offers. Another example in the same is display of goods in shop with price tag is an invitation to offer, and offer is constituted when customer opts for the product. So in this particular case, there is a case law where one company offers that this particular product is available, and the other person asks for the price, and the other person says that okay, I'm ready to buy that, and the first party refuses. So there are a number of case laws which we are going to discuss in the separate class. Similarly, catalogs and price list, inviting tenders, all these are the example of invitation to offer. So once the invitation to offer take place, the other person is going to make an offer with respect to which he is going to buy, and then the first person, either he can be the same person inviting the offer or there can be someone else, and if they give their acceptance, then in that particular case, there the particular agreement, and considering that all the related essential elements are present, it will turn into the contract and will give rise to the legal obligation. Right? And
Ma'am, I
one
have a
second,
doubt.
1 second, picture. Wait for a minute. So I think till this point, the